We're on the record.
Thank you. Good morning. This is the July 20th, 2023 meeting of the Syracuse Regional Board of Review. This hearing is being held via video conference call WebEx at the following locations: Hughes State Office Building, Main Hearing Room, first floor, 333 East Washington Street, Syracuse, New York, 13202, and New York State Department of State, One Commerce Plaza, Conference Room 1112, 99 Washington Avenue, Albany, New York, 12231. Time now is 9:37, and this hearing is officially open. The members of the board are Gail Swistek, to my left, to my right, Mr. Jeffrey Hinderleiter, and to my far right is Andrew Garlock, and remotely from the Albany conference room, room 112, is Jacqueline Coons. From time to time, we will hear from the Department of State, Mr. Thomas DiTullio, who is our technical advisor. We'll now hear the scheduled petitions. When you speak, please address the board and give your name, title, and legal address so that a court reporter can have all the information requested. We may have to stop from time to time to consult with our technical staff. Making comments to the board, please provide a descriptive narrative on the matters referring to your exhibits to enable the court reporter to enter these into the record. Our first hearing this morning is in the matter of No One LLC petition number 20230285. The applicant is seeking relief just bear with me 1 second. Seeking relief from Chapter 61B of Consolidated Laws of New York State, Multiple Residence Law, Article 3, Section 26, and Chapter 61B of Consolidated Laws, Multiple Residence Law, Article 3, Section 28. And those are the only two items they're seeking relief from. Do we have the applicant here in the room or online that would like to speak? It doesn't appear we do. So do I have a member of the board would like to make a motion and read the determination?
You do.
Mr. Hinderleiter?
The petition pertains to a variance seeking relief for 6 dwelling unit apartment building construction type 5B, 3 stories in height, located at 511 to 513 Wetmore Street, City of Utica, County of Oneida, State of New York. The public notice is published in the New York State Register's June 7, 2023 issue. The petitioner is seeking relief from Chapter 61B of the Consolidated Laws of New York, Multiple Residence Law, Article Section 26, egress from dwellings. Says, in every such dwelling, 3 stories or more in height, there shall be from each story at least 2 independent means of egress, accessible to each apartment or suite. The first means shall open into a public hall connected with stair affording safe access to a street, or to a yard, court, or passageway affording continuous, safe, and unobstructed access to a street. The second means shall be directly to a fire escape or an enclosed stair without passing through the first means, except that where the first means includes an interior stair which is closed off at each floor level by fire retardant construction with a fireproof self-closing door therein, the second means may be another such interior stair or a fire escape directly accessible on the same story from a public hall, therein whether or not the public hall is also a part of the first means provided. Such fire escape is not a wire, chain, cable, vertical ladder, or rope fire escape. In lieu of a second means of egress, a sprinkler system may be installed in the public hall and stairs. Petitioner also requests relief from Chapter 61B of the Consolidated Laws of New York, Multiple Residence Law, Article 3, Section 28, Stairs and Entrance Halls, where it says, in every such dwelling 3 stories or more in height, the wood wainscoting and other combustible materials on the wall and ceiling surfaces in all halls shall be removed. In lieu of such removal, a sprinkler system may be installed, or such wainscoting and the combustible surfaces may be treated or covered with a surface fire retardant approved by the department. In such a dwelling, any entrance door and every door opening, entrance hall, stair hall, and other public hall therewith shall be self-closing. The petitioners request relief to the above sections with the direction of the local fire marshal. Based on the testimony and documentation presented, the board makes the following findings of fact. 1. The petition pertains to a mixed-use building, 3 stories in height, 6 dwelling unit apartment building with 2 apartments on each floor, located at 511 to 513 Wetmore Street, City of Utica, County of Oneida, State of New York. 2. The building that is the subject of the petition is properly classified under Chapter 61B of the Consolidated Laws of New York, Multiple Residence Law, Article 1, Section 433, as a multiple dwelling. 3. The subject building is required to conform to the provisions of Article 3 of the Multiple Residence Law as provided in Section 25, in that it existed on or before July 1st, 1952, or was converted to a multiple dwelling after July 1st, 1952, and is not a hotel or similar dwelling subject to Article 4 of the Multiple Residence Law. 4. The building that is the subject of the petition is a 3-story wood framed, approximately 3,834 square feet in area, with 2 apartments on the 1st, 2nd, and 3rd floor. The building was constructed in or about 1960 as a 6-unit apartment building. 5. The building is subject to a variance granted in October 2011 for Article 3, Sections 30 and 31. 6. The petitioner stated that installation of door closers at each door servicing any apartment will be installed. 7. The building shall otherwise comply with all other local and state building codes and local ordinances. 8. The local code official has been consulted in this matter and supports the granting of a variance under Part 1205 with conditions provided by the board. In view of the above findings, testimony and documentation presented before it, the board finds that strict compliance with the code would entail practical difficulties, unnecessary hardship, or would otherwise be unwarranted because such would be physically or legally impracticable, would be unnecessary in light of the alternatives which, without a loss in the level of safety, achieve the intended objective of the code, and would entail a change so slight as to produce a negligible additional benefit consonant with the purpose of the code. Wherefore, it is determined that the application for a variance from Chapter 61B of the Consolidated Laws of New York, Multiple Residence Law, Article 3, Sections 26 and 28 be proposed to be granted with the following conditions. 1, that each apartment door shall have self-closing devices installed to the satisfaction of the fire marshal. And 2, that all wood, wainscoting, and combustible wall, ceiling, surface materials, including the doors, in the stairways and hallways shall be painted with fire retardant intumescent paint to be to the satisfaction of the fire marshal. I so move.
A motion.
Second.
And a second by Swiss Act full board. Mr. Garlock. Ms. Coons. She raised her hand. Aye. Okay. Ms. Swistak.
Aye.
Mr. Later.
Aye.
Chair votes aye. 5 ayes, no nays. Variance is granted. Thank you. For the remainder of the hearing.
On your name.
I got it.
We're also muted on.
Thank you. For the remainder of the hearing, Ms. Swistak is recusing herself and will be leaving the room. So we can move on to our next case. Okay, we're on to our next hearing. This is in the matter of petition 2023-0335. Party is Anthony Rojas of In Architects LLC. The petition is regarding a property located at 7. Excuse me 1 second here, make sure I get the right address. 719?
Yes, 719.
East Genesee Street. Okay. And the petitioner is seeking relief from 19 NYCR Part 1221 Building Code of New York State, Section 705.8. Allowable area of openings and maximum area of unprotected and protected openings permitted in exterior wall. The story of a building shall not exceed the percentages specified in Table 705.8 based on the fire separation distance of individual story. And let's see, we have the applicant here, Mr. Ross. Would you like to go ahead and give us state your name and your address, and then give us information on your project and what you're seeking for relief?
Sure. Good morning, everyone. My name is Anthony Rojas. I am principal here at In Architects, representing Foundation Housing for 719 East Genesee Street. We have submitted drawings that show that our existing, there's an existing 3-story structure. The property line is right on the building's exterior facade. So there is essentially a 0 lot line structure on all the way around our building. As I zoom into some of these pictures here, you'll notice that the 2 walls in question in which we're proposing additional windows currently have existing windows along this facade here. This is the western elevation. I don't know why my screen has frozen here, but I can't move it. So these are existing windows along the western elevation, and we're proposing to increase the percentage of opening window area by 1.8% along this western elevation. This photo here shows the eastern elevation, again with existing windows, and this area also has a 0 lot line along the property line. This east elevation, we're proposing a 0.6% increase of window area. The windows that are proposed are specifically for the residential units that are proposed on the interior and redevelopment of this project. It would be mostly into shared living and kitchen areas within these new bedroom layouts or within private bedrooms themselves, which would otherwise create a hardship in being able to lease these spaces to new tenants without natural daylighting into this proposed use. So we're requesting, permission to increase the amount of openings. The building is fully sprinklered, and the system will be modified. We will be adding additional sprinkler heads over each window along the exterior to add an additional layer of protection for these new openings and existing openings along the east and west elevations to protect themselves from any adjacent structures. The second item, and I don't know if this is something we can speak about if the board would consider today, but in response to the letter that Brian Thompson has provided you all on behalf of the city of Syracuse, he did mention a second item that if you'd be willing to listen to, I'd love to be able to, offer some additional information on. He had question about one of the existing stair openings. We obviously have 2 stairs. One is this existing stair on the back, which is fully enclosed and meets all levels and down to grade. So this is not in question. The question that he had mentioned and would like some guidance on is this stair over here that wraps the elevator. You'll notice that this stair currently has doors that are on closers, and it separates the stairs from the level at each level. But once you land on the level down below, it opens itself up to the elevator lobby where the existing elevator is located. So you essentially have to leave the stairwell to then go back down to enter the staircase again. And in the sections that he noted as the issue of existing building code 1011.4, if you go to those sections and then you kind of read through, and it goes back, referring you back to chapter 9 and then again down to chapter 8. Section 802.2.1, we meet all of the exemptions on item 3, where this enclosure shall not be required, because we provide the building with automatic sprinkler system. We exit on the lowest or next to lowest level on the street floor. The entire area is open and unobstructed in a manner so that it's reasonable to assume that there's a fire in any part of the interconnected spaces. And so all those 5 items on that section, we do meet as an exemption for it to not necessitate a complete enclosure all the way down to the ground, aside from, based on the existing building code. And this is a historic structure as well. So I believe those are the 2 items that we'd like the board to consider to hopefully offer, relief in terms of the openings on the exterior, and provide some insight on the concern that Brian expressed on this staircase, which we hope you also agree that it's an existing condition and would still allow for safe exiting in case of a fire through the existing staircase.
Okay. Questions for the applicant?
What was the previous use of this building?
This was mostly commercial. There was office, private businesses, offices in this building.
So you mentioned modifying the sprinkler system. When was the original sprinkler system installed?
I don't have an exact date, but I believe it's been installed for the life of the building. We are going to completely gut the existing system and replace with a brand new system. The building needs a backflow preventer, and we will be, putting a brand new system into the building.
Okay, so it's not a modification then of the sprinkler system, it's a replacement of the sprinkler system.
Correct.
And that'll comply with probably this one if it's residential and at PA 13R or 13.
I believe it's 13, if I'm not mistaken.
Yeah. Okay. And generally, when looking at existing buildings, we want to be able to reutilize existing buildings. The code prioritizes that versus new buildings. Part of that premise is that we're not going to either increase areas of nonconformity or make the building less safe. So it's your argument that by replacing the sprinkler system and making the windows inoperable, that you're saying that makes it as safe as it currently stands or safer?
Yes, the windows will be inoperable, and we will be adding additional sprinkler heads right over the openings in case of any, incident that may occur. That'll be an added layer of protection because there currently are no sprinkler heads over the openings.
Are you addressing as part of it? So windows, the code requires having light for residential units and fresh air. How are you? If we're going to have inoperable windows, are you?
We are
ventilation that bring fresh air into the building.
Correct. We'll be adding a makeup air unit that allows fresh air intake into the building so that we don't need the windows to be operable.
Have you spoken to the adjacent property owners?
We have and have mentioned the use of the reuse of the building and its proposed new life, and they've never raised a question. He's actually a structural engineer, and we've worked with him on projects, other projects throughout the city. So he never expressed any issue, and we had mentioned the new openings and has never really expressed any issues with it. We actually have a structural engineer to our west and MEP engineers to our east, right adjacent to us on either side. And we've worked with them both, and neither have expressed any issue with the redevelopment plans of this building.
Any other questions for the applicant? Mr. Garlock, do you have any questions? So the windows are technically not code required for any purposes, correct? The additional windows that you're installing.
So we would need daylighting into the units, especially those one-bedroom units, and to any kitchen and living area. We'd want daylighting into those units. But by code, I don't think that we do. It would just create an issue in leasing those spaces and having those spaces be viable without any natural daylighting into them.
What happens in the future should the adjacent landowners on either side want to build up to the party wall with a code compliant structure without any agreements or easements in place?
So the existing owner understands the possibility of that happening and the possibility of losing those windows at some point. Any developer in a downtown type of condition would understand that there's a risk in doing this, but they are willing to take on that risk and allow for these windows to be installed as long as they can be for. If there's a need to shift in the future because there's a new project proposed next door, then she would obviously take care of the issue at that point.
Are you proposing that these windows are fire rated?
Not at this point.
Ms. Coons, do you have any questions for the applicant?
Yeah, there's no MEPs with these plans. Maybe it's in the application somewhere else, but can the applicant describe the fire detection and alarm sequencing in this building that's proposed?
I can email you a copy of the MEP drawings so that you have that on record. Both the interconnected, fire alarm system will be upgraded to meet code, and new sprinklers throughout the entire building. So everything will be up to the new, code and based on its proposed use.
So the apartments are all regular detectors. It's not a full fire alarm system because it's not a commercial use, it's a totally R2 use. Is that what you're saying?
It'll be an interconnected, fire alarm system. So each of the units will be, connected and alarmed so that if a unit has an issue, all the others will be detected. So,
but centrally monitored or not centrally monitored?
I don't think that they'll be centrally monitored with any,
So just one fully interconnected system. So if one apartment has an activation, all the other apartments get notification.
Correct.
But the fire department does not get notification on the initial alarm?
That I would have to verify and see if the engineer put that in there. I'm not 100% sure off the top of my head here.
Okay, thank you.
Okay. Let's
Okay.
see. Code enforcement official, Mr. Thompson.
Good morning.
Good morning. State your name and your address, sir.
Yes. Brian Thompson, BrianThompson. Address is 201 East Washington Street, Road 101, Syracuse, New York, 13202.
1 second. How do we get the camera on Mr. Thompson?
Not have video on? Are we only on the? Got him on there.
There we go.
Okay.
Forget it.
Would you like to repeat that?
Maureen, did you hear Mr. Thompson's address and information?
I did, thank you.
Certainly.
Okay, to answer a question that Mr. Hinterleiter asked, and you can keep this if you want, that's a copy of the certificate of occupancy that was issued. You'll notice that it's a C1 occupancy. Although I don't have a certificate of occupancy specific to the third floor, a couple of years after that was issued, in I believe it's 84. This was a permit that was issued and assumed to be completed for, again, expanding that office use. So to your question of what the building was legal for, since the 80s, it was an office building.
Okay. For the record, we're going to need to enter these in as exhibits. Tell me what are we?
Yeah, I guess switch. I think it's either.
How about we'll do those as exhibit A and exhibit B?
Here we have those.
All right.
How about exhibit 1,
Exhibit 1, exhibit 2. Okay. So exhibit 1 is a certificate of occupancy. Dated 21st November 1984. And second is a permit application for the structure expanding the business use. Okay. That's exhibit, that'll be exhibit 2. Okay, those are, go ahead. I'm sorry.
Chief Davis is unable to attend today, so if you have any questions, I did speak with him before coming here. The east side of the building, and as Mr. Rojas displayed his screen previously, the bottom side of the page would be the east, top side of the page is west. So the east side of the building where that stair in question, one discharges, we'll talk about the openings for a second. We'll have to prove an easement in that area to connect back to the public way. So the city is less concerned with the openings on that east side of the building, or again to the bottom of the page. The concern or question is more to the north side of the building, where there is an adjacent existing building. I don't have information on the type of construction. It looks to far predate our records when it was constructed. Likely it looks like it probably was made, but I can't speak that specifically. Just based on Google Maps, it looks like it's maybe within about 10 feet. That particular property, which is known as 717, which again is to the west, what has been proposed to be redeveloped, although those plans seem to have been kind of dead in the water at this point, it does show an interest in the potential redevelopment. So the city's concern is really what's happening on the west versus the east, which theoretically will have an easement before this permit is issued to show a legal exit discharge from that, what would be the south east exit back to the public way. So again, the city's a little wary of what's happening to the west more than it is happening to the east.
Okay.
So in terms of
just one clarification, yes, Mr. Rojas could answer this, but you may be able to answer. On the west side, there are already existing openings, correct?
Correct.
Okay, so that's in the condition that was permitted in 1984.
I don't know when those openings were allowed, but yes, they appear to be lawfully existing. I don't have any
Okay,
record showing that they're not legally there.
okay. The, in the north side, you said there's about 10 feet to the structure, behind it.
To the west.
Oh.
No, to the north would be at Orange Alley. It's a 20-foot wide public way. To the south would be, so the north would be the right-hand side of the page. The left would be the south side facing Genesee.
Okay, so the north, but you said the north side was, there's a
Well-
building 10 feet away.
West. It would be to the top of the page, but it is the west side. I apologize if I
It's the top of our page. It's like.
Oh, I'm sorry, yeah. Oh,
We're looking at
Yeah,
it
it's-
two different ways.
okay, I'm sorry. It's Mr. Rojas that displayed his screen before.
So the east is the front of the building.
There you go, right there.
East would, the front of the, as you would face the building from Genesee is south.
Front of the building is south, rear of the building is north. Two-story brick frame building is to the east. Wood frame building is to the west.
Gotcha. Trying to get this. On the east side, they will have to get an easement for the exiting.
Yes, that would be chapter one, and the property maintenance code both require access to the public way.
Mr. Rojas, are you in the process of establishing an easement?
Yes, they're in communications to see how they could, if they either want to establish an easement or have some kind of 100-year lease agreement or some kind of written agreement that would continue the understanding that they both utilize that area. Both of those buildings utilize that area for handicap accessibility into both structures and for egressing. So both parties are aware and in communication, and will come to some sort of agreement. They're just trying to legally, work that out between both legal entities.
So what about the west side? Have you attempted to establish an easement over there with the adjoining property?
No, we have not attempted that pathway or requested that of the current building owner. It is on a 0 lot line. The east side is a little easier because of its previous use and the understanding that there are between both parties. The west side, we feel it would just create a burden on that current property owner of narrowing their site even further. So our current property owner is the one that's willing to take the risk of understanding that if there were to be a future building proposed, that they would have to deal with the windows and how many there are, and potentially even closing them at a future date.
If 717, this is a question for the city of Syracuse. If 717 were to be redeveloped as an infill lot, what's the zoning in this area will they be permitted by current zoning code to build a 0 lot line building? Or was that a variance for local?
We just changed, as of the first, our zoning ordinance, so I apologize, I'm not up on it yet. I believe there would be no setback in that district, though. I could be mistaken, but it's my belief that there would not be. I can tell you what was proposed about 2 years ago-ish, was a 19-story building that was 3 feet from the property line.
What percentage let's just stick on the west side, and I think that's the most common concern here. I mean, the existing condition is what it is, but the applicant's investing a lot of money to rehabilitate this building to use for housing.
Correct.
In a matter of 3 or 4 years, it could all be lost if there's another development proposed on the 0 lot line. So the question comes back to is, what's to prevent? I mean, we know what the new link property owner's gonna have to do if they build on zero lot line. They're gonna have to build a wall that's gonna be compliant. And yet we're putting this situation in a financial and a community jeopardy that people may have to be relocated who are residing in this building because it no longer meets code, because the windows have to be closed up, or they would exist, but they would be looking at a brick wall. I guess I would feel better if there was some assurance that there would be 3 feet, along that side.
The city agrees with that. If there was some measurable distance, then we could, you at least have established that there
Right.
can't be structure within that range. The fire department for Chief Davis, his thoughts were either some type of easement, which, as Anthony said, if you already have a narrow lot, to narrow that more could be burdensome on the neighbor, or potentially fight-resistant rated windows. I know in the past, the board has allowed for that water curtain protection, but never when there was an adjacent structure.
Right.
So
Shutters are a possibility. But fire rated shutters, but they don't be interior, they don't be mechanical. It doesn't solve the light issue that they're gonna face, and that's the other thing. And the top floor, obviously, they could probably achieve some level lighting, but
although we haven't spoken about shutters this particular time, and by we, I mean myself and Chief Davis. In the past, the fire shutters he's been very wary of fire shutters because people put things on the windowsill and then they don't function.
understood.
In regard to the stair item,
Sure.
gears for just for a second. It's 1011.4, it's within the change of occupancy chapter of the existing building code. It is for the general means of egress, like the hazard level. The change is a higher hazard to residential. So what may be provided, I would defer to you and both the design professional in terms of is leaving the enclosure safe because it's an existing condition to re-enter, but because it's a change to a higher hazard, that has to be, the means of egress has to meet with the exceptions listed, has to meet the new code, which is a continuous unobstructed path. So, which an elevator doesn't open into, and that's very hard when your existing stair wraps your elevator. So the city doesn't object to any relief that is offered for that, but just anything that makes sense would work. Just would rather not come back twice if we don't have to.
Yeah, I mean, if the elevator's lobby is fire rated around and there's no open corridors, I could see that. I mean, the elevator does not exist currently. This is part of the design, or is this?
No, this is an existing elevator.
Oh, it is
an
an
existing, that wrapped by an existing stair.
So this is all existing.
Once they leave that story above, now it's all open here. So current code, they have to actually close.
It's closer, but then you have the elevator opening into the stair, which is also prohibited. So it's like you can't really win in that configuration.
Unless you do 1 hour, the dwelling separation, even with the sprinklers. Because you only need half an hour. It's for sprinkler. Right?
Yeah, it's not.
There's the doors to the dwelling unit. It's just trying to isolate the risk. The risk is in the dwelling units to escaping to the court.
Correct. It's also the fact that there's no way to open that elevator not into a stairwell once you enclose it for.
Right.
Yes.
So it's just allowing that, I guess, that either the stair not to be totally continuous or the elevator to open into a stair enclosure. And again, the city doesn't object to that. I would just rather not have to come back twice. So. And it's really not for me to ask.
Right.
It's for Anthony.
No, I understand. Mr. Ross, speaking for myself, I think I'm more concerned about the west side of this building and not being on a zero lot line. I think even though there are existing openings, we're changing this to residential. And that change, as Mr. Thompson alluded to, is a higher hazard. I'm a little reluctant to be supportive of a variance for the west side particularly. Within, if just, and I can't think of any mitigations. The sprinklers on the windows, just as if they were operable windows, or just as shutters are there, there's always possibilities for sprinklers to be obstructed, such as shades, curtains, and things like that that can be placed on the inside between the sprinkler head and the window itself. I've seen these situations occur in other events where we granted window sprinklers and somebody hangs something up between the sprinkler and the window, or they do something to obstruct the sprinkler. So the sprinkler, while in its perfect installation, meets the necessity to get simply a minimal rating, doesn't meet the rating of the firewall by any means. And if that sprinkler's impacted by anything, then the sprinkler is ineffective. So I'm struggling on the west wall without some type of assurance there would be some distance between it and the neighboring building.
Sir, if I may, am I allowed to make a comment?
Sure. Oh, absolutely. This conversation.
Okay, thank you, sir. So if there were no new existing windows, I'm sorry, any new proposed windows, and we were converting this structure into the proposed use, which is multi-unit residential, we would still be able to have that use with the existing windows that are there and not be seeking any variance because it's the current condition.
Right.
And we do have, and you see the breakdown in kind of my letter to you, that the increase of percentage, or 1.8% on that west elevation is not a substantial increase when we think about kind of the existing windows that are there currently. So this just allows for it decreases the burden on the current owner in being able to lease these spaces and have usable area with daylighting on the interior. So it really is, if we have to work around and not have those windows, we would still be applying for this use. We would still be having the residential, the multi-unit tenants on the interior, and we would still be utilizing the existing windows and still have the same concerns. So I would ask that, the board really consider that the increase is so slight and reduces the burden on the current owner, that we don't see any increase in hazard of any issues that may, or the future building of a future construction of a building adjacent is still going to create issues with the existing windows that we know we will have to deal with, and the owner understands that, and it still creates the concerns. It's just the project will still move forward with the existing windows.
You're adding 7 windows on the west side.
Correct.
And there are roughly 8, and this is just on the second floor, and there are roughly 1, 2, 3, 4, 5, 6, 7, 8 windows existing. In essence, you're doubling the number of openings. Understand the percentages. I'm talking about the number of openings.
And I would be, to be honest, I would be willing to, reduce the amount of windows on the west elevation if quantity is the concern. I can have bedrooms that have no windows, as long as my kitchen and living areas do. So if quantity of windows is the concern, I could definitely reduce those. But know that your primary concern even if I have 0 windows, approved, the use is still going to be the same, and the existing windows will still be of similar concern. So I don't think there's an increase of level of concern, right?
Well, you have where the new windows are going. I think the plan calls them bedrooms, but they look like kitchens. I assume that's a typographical error.
So there are, and I could
Third
pull up-
floor.
Yep.
Drawing 8204. It's like room 303, 304, and 305. Those are new windows.
Allow me to pull that up here. 3rd floor. So this new window here that's into the bedroom, I can get away with not having that window there. But this 1-bedroom unit here, these windows here are into the kitchen living areas on each of these.
What
Right.
I'm highlighting is that, correct me if I'm wrong, Mr. Parsons, but I believe one of the leading fire risk in a residential use is usually the kitchen, something that, something goes wrong in the kitchen, either oven or cooking something. As far as a risk to an adjacent building, that's probably a higher risk versus if that was a bedroom. From your design perspective, I understand exactly why you want the windows and why they make sense where they are and that it's again, I share the concerns on that west side, being that if we have to be careful that we don't, and you look at your building, we all have to be good neighbors. And so if the city of Syracuse now permits that adjacent building to be a 0 lot line building, I'm not sure we have the authority to inhibit anything on them. They're not the applicant. That's not our role, is to look at the neighbor and say, well, now they can't because we permit this. So we can only regulate on this side of the property. And understanding that, the property owner is comfortable with taking some sort of risk. But for us, it's, I share the same struggle kind of on that west side, that while the percentages don't seem like much, it is doubling the number of openings almost. It is that some of those openings are increased risk areas. If I would see some of that mitigated with if the windows are fire rated as far as that goes, but the light and the usability of those units, if that's the whole reason the window's going in. I guess from a fire perspective, it's probably easier to get to in that we can, if you put a fire rated window in and can increase that piece, is probably seems reasonable to me. But it still doesn't solve the light problem.
If it would, ease the concern of having all of the windows that are adjacent to kitchens along that exterior of the west elevation, if all of those new windows that are proposed in those rooms be fire rated, I'm sure the owner would be willing to replace those windows with fire rated units.
Any board members have, Ms. Coons, do you have any questions for the code enforcement official? Jake? No? Okay. Mr. Garlock?
Yes, just one question about that, the exterior walls. What are the code required fire resistive ratings on those existing walls?
I believe they're 1 hour, if I'm not mistaken. 2 hour bearing walls on the exterior.
Okay, sorry.
2 hour flash. Yeah, I know.
2 hours.
Yeah. Expensive.
Yeah.
And if the fire shutter is also, you know, I don't know the cost differential on behalf of the owner, and I don't want to be spending her money here, but if that's again another consideration or suggestion from the board.
We have any other comments? Mr. Thompson?
Unless you have questions.
No, I think we're all set. Thank you. Mr. Ross, do you have anything further to say regarding?
No, the only thing is, you know, we you know, speaking on behalf of the owner, we obviously, you know, would like to have the windows and would be willing to make concessions on, again, additional protectives to allow for that use. So we hope that the board does consider that as the path forward, and we'd be willing to, you know, work with and provide any of those alternatives to allow for the increase of window area. So whatever those suggestions are, then we'd be happy to implement those and, you know, discuss those with you guys.
I don't have anything further. All right. So we're going to go into recess while we do some deliberation on this. And so we just ask folks to leave the room, and we will be going off the record and to begin with deliberation.
Off the record.
Thank you. Rain, we can go back on the record.
We're on the record.
Thank you. We're out of a recess. We're coming back to just continue a conversation regarding petition number 2023-0335 regarding 719 East Genesee Street, Syracuse, New York, Anthony Rojas of In Architects LLC. To begin with, the board's, and this is from Mr. Rojas. We're, as you can tell from the questions, we are struggling with this whole opening issue on the west side without easements. I think if there were easements, we could deal with a 0 lot line. It's just we can't come to any agreement on how this could be done with a mitigation that doesn't create a greater hazard to the building and to the occupants. So we have just a choice for us right now is, since you're in design, do you want to go back and take a look at this and then come back to us on the same application, or we can make a determination and then you can respond back and do a second application. We are not going to take action relative to the stairs because frankly, we didn't see anything proposed for mitigation, and really you had, other than you brought it to our attention, it needed variance. I don't think we had a chance to understand what the options were for any mitigation. So we are not going to act on that. So you will have to come back on that under the current design for some type of variance if you so choose. So with that, I will ask for a motion. Mr. Garlock?
Yes. Mr. Chairman, I'd like to make a motion with respect to the petition Anthony Rojas of In Architects LLC, petition number 2023-0335. Petition pertains to Anthony Rojas of In Architects LLC, 239 East Water Street, 2nd floor, Syracuse, New York, for Housing Foundation, 719 East Genesee Street, Syracuse, New York, for a variance seeking relief for additional windows at exterior walls on the property lines for alterations to 31,300 square feet, mixed-use building with commercial tenants on the first floor and apartments on floors 2 and 3. Construction type 3A, 3 stories in height, located at 719 East Genesee Street, City of Syracuse, County of Onondaga, New York State. Public notice was published in the New York State Register, July 12, 2023 issue. Petitioner is seeking relief from 19 NY CRR Part 1221, the Building Code of New York State, Section 705.8.1, which states that allowable area of openings, the maximum area of unprotected and protected openings permitted in an exterior wall in any story of a building shall not exceed the percentages specified in Table 705.8 based on the fire separation distance of each individual story. Table 705.8 maximum area of exterior wall openings based on fire separation distance and degree of opening for protection states that the fire separation distance of 0 to 3 feet, degree of opening protection that is fully sprinklered, allowable area allowed is not permitted. Petitioner is seeking relief for a variance to allow additional windows in the exterior east and west walls of the 2nd floor through 4th floors at the new apartment locations where the walls are on the property line. Board makes the following findings. 1, subject petition pertains to alterations and change of occupancy to an existing building located at 719 East Genesee Street, City of Syracuse, County of Onondaga, New York State. 2, the building subject to the petition is properly classified for NY CRR 19 Part 1221, Section 303.3, Group A2 occupancy includes assembly uses intended for food and or drink consumption, including but not limited to restaurants and cafe. Section 304.1, business group B occupancy, offices. Section 309.1, mercantile group M occupancy includes, among others, the use of a building or structure or a portion thereof for display and sale of merchandise. In Section 310.3, residential group R2 occupancies containing sleeping units or more than 2 dwelling units where the occupants are primarily permanent in nature, including apartment houses. 3, the building subject to the petition is properly classified for NY CRR 19 Part 1221, Section 3B, unprotected, fully sprinklered, 3-story building with an occupied room totaling 31,300 square feet. 4, the petitioner is seeking relief to install additional window openings in the east and west walls that are on the property boundary. Section 705.8.1 refers to Table 705.8, which states that any residential occupancy with a separation of less than 3 feet of any opening in the required 2-hour rated exterior wall is not permitted. 5, the petitioner states in Exhibit 1 that the building is 9,200 square feet per floor, 1st through 3rd, with a partial basement of 3,100 square feet. A partial roof deck addition of approximately 750 square feet is being proposed. The building is fully sprinkled. The existing system will be modified to reflect the renovation work. 6, petitioner states in Exhibit 1 that they are proposing 2 new window openings on the east elevation where there are currently 16. They are also proposing 7 new window openings on the west elevation where there are currently 11. 7, the petitioner states in Exhibit 1 that the new windows will be fixed windows and inoperable. It is proposed to provide additional sprinkler head coverage for the new and existing windows per the direction of the City of Syracuse Fire Department. 8, the petitioner states in Exhibit 1 that on the east elevation window area is 376 square feet, which is approximately 5.2% of the wall area, and that the proposed increase of 48 square feet would be an increase of 0.6% for a total window opening area of 5.8% on the east elevation. 9, the petitioner states in Exhibit 1 that on the west elevation, the existing window area is 327 square feet, which is approximately 4.5% of the existing wall area, and the proposed window area of 130 square feet is an increase of 1.8% of wall area for a total of 6.3% window area opening on the west elevation. 10, the petitioner's Exhibit 2 construction plans notes that there are existing window openings on the east and west elevations of the building, and the additional windows would not be a significant increase in area of openings. 11, Exhibit 2 construction plans note in drawing A100 that the adjacent building, 721 East Genesee Street, is a two-story office building type 2B construction and abuts approximately 35% of the east elevation of the subject building. 12, Exhibit 2 construction documents also notes that there is a shared existing handicap access ramp and courtyard between the subject building and 721 East Genesee Street on the south elevation or Genesee Street side. 13, Exhibit 2 construction documents also note that on the west side of the building, an existing 2.5-story office building known as 717 East Genesee Street is located approximately 8.5 feet from the property boundary. The parking lot is located behind 717 East Genesee Street, as well as the subject building's parking lot. The local code office has been consulted in this matter, does not support the granting of the variance under Part 1205. In accordance with the above findings, the board finds that in the case before it, insufficient evidence has been provided to warrant a variance under the ground provided in 1205, and provisions for health, safety, and security will be adversely affected. Therefore, I move that the above petition be denied. Furthermore, it should be noted that the decision of the board is limited to the specific building and application before it as contained within the petition and should not be interpreted to give implied approval of any general plans or specifications presented in support of this application. So move.
I have a motion. Do I have a second?
A second.
Mr. Delighters. Seconds motion. Hold the board. Ms. Coons?
Aye.
Mr. Delighter?
Aye.
Are we? Oh, aye.
I think I am.
Heard you. And the chair votes aye.
I think I am.
4 ayes,
It's on.
no nays to deny the application. Mr. Rojas, Mr. DiTullio will be in contact with you, just give you some suggestions that we talked about. Thank you.
Thank you. Appreciate it.
Mr. Chairman. One second.
Maureen, this is Tom DiTullio. On the additional exhibits provided by the city of Syracuse, could we change those to A and B versus 1 and 2?
No.
Thank you.
Okay. On to our next case. And our next petition is 2023-0336. Party is Jeffrey Cross of Code Red Consultants for Syracuse University. Petition pertains to a variance seeking relief for exceeding allowable area for demolition reconstruction of football operations of section of the John A. Lally Athletics Complex located at 1301 East Colvin Street, Syracuse, New York. And do we have the applicant? Yes. So I'll make sure that, yeah. Just tilt it back a little bit. Yep. Exactly. Okay. All right, each of you just state your name and your address for the court reporter.
Good morning, my name is Tom Weirs. I'm the project architect with Gensler, located at 2020 K Street Northwest in Washington, DC, 2006.
Morning, Joshua Apolinas with Code Red Consultants and the Fire Protection Engineer. Our address is 154 Turnpike Road, Southborough, Massachusetts, 01772.
Okay, you want to give us a little background on your project and what you're requesting?
Yes. So again, good morning and thank you to the board for hearing our application for the variance. This is
I'm sorry, who's speaking?
we're just,
Tom is your first name?
yes.
Okay, thank you.
Okay, my name is Tom Weirs. We are representing Syracuse University for the John A. Lally Athletics Complex on East Colvin Street in Syracuse. The complex was formerly known as Manley Fieldhouse. It was originally built in 1962, and over the years it has grown through numerous additions and renovations. This project is part of the first of a 6-phase master plan to renovate the entire facility. And as part of this project, the existing football wing will be demolished and a new expanded football wing will be built in its place. We had previously worked on the Phase 1A entrance project with Syracuse and the city, which was completed earlier this year, and this is Phase 1 of that project. Previous renovations and additions were allowed by earlier versions of the building code to construct 2-hour fire barrier separations between the existing and new construction in lieu of firewalls, which are required by the current code. Therefore, the existing building exceeds the allowable area permitted by the current building code for a building constructed with Type 2B construction. As part of this project, a new 2-hour structurally independent firewall will be constructed to separate the new football wing from the remainder of the existing building. The reason for this hearing is because on the existing site of that new firewall, we are infilling a small portion of the previous building footprint that is being demolished, and we are also adding a small area to the existing footprint. It's very important to note, and as depicted in our variance application, that the total area of the existing non-conforming building is being reduced via the installation of the firewalls between the Simmons wing, which was part of the Phase 1A project in preparation for this, and the new football wing. Therefore, the result of this project is a building that is more compliant with the building code of New York State than it was prior to our project. This approach aligns with the intent of the existing building code, in that it's always the intent of the building code to make buildings more safe than they were prior to an alteration or addition being performed. Now I'll turn it over to Josh for more insight.
So the construction of the new football wing will be Type 2B construction. As Tom noted, will be fully separated from the existing building by a code compliant 2-hour fire resistance rated firewall. And then the construction of the infill area, which is classified as an addition under the existing building code, is what's driving the need for the variance today. Typically, when an addition occurs to an existing building, the addition along with the existing building is required to comply with the New York State Building Code for allowable height and area provisions. The firewall is located between the football wing and the infill, was very strategically located due to significant structural challenges of abutting the existing footings against the field house structure. The structural constraints did not allow for us to locate the firewall such that the infill area was part of the football addition and was completely separated from the remainder of the existing building, and is the main driver for this variance request, as the existing building currently exceeds the allowable area of the building code as it is existing. In order to provide a solution that meets the intent of the building code, we're proposing the following mitigation measures be provided within the infill area in order to increase the level of life safety and overall building code compliance to a level that is consistent with what would be mandated via prescriptive code compliance. The first mitigation measure would be that we construct the infill area as consistent with Type 1B construction, which would consist of 2-hour fire resistance rated primary structure, beams, columns, 1-hour fire resistance rated roof, and would increase the level of structural integrity and life safety within that infill area and existing portions of the building that are between the 2-hour fire barrier and kind of the infill, as noted in figure 2 in exhibit 1. The second mitigation measure that we're proposing is to increase the hazard classification of the sprinkler system within the infill area to be consistent with an ordinary hazard group 1 classification versus what's required by NFPA 13 as a light hazard classification. This increase would provide a 50% density increase over the fire area throughout the infill and would supply 50% more water to, control and likely suppress any fire event that did occur within the infill building. It should be noted that in paragraph 3 of the letter provided by the City of Syracuse Division of Code Enforcement, the city acknowledged that they agree with the justification as set forth in Exhibit 1, the variance letter, and took no exception to the proposed mitigation strategy. We believe that these measures should be considered by the board as providing a level of life safety that is consistent with the intent of the prescriptive requirements of the Building Code of New York State, and we hope to receive your approval on the variance application.
Okay. Questions from the board members. So start with Ms. Coons. Do you have any questions for the applicant?
Not right now.
Mr. Garland.
Yeah, so to get a better idea of the existing fire area, you're demolishing a fairly decent portion of the building to construct the infill plus the new football operations wing. Can you speak to the existing fire area? The existing fire area that is being demolished, and then the fire area, the size and square footage of the fire area that the infill is a part of?
Yes.
Just for comparison.
Yeah, I'm trying to find in our exhibit the overall square footage of the construction. Just give me a moment.
I think the only thing we didn't note is the exact size of the existing portion that's being demolished.
Yeah, so the overall building as it currently is 167,000 square feet. The area of the building being demolished, we can send you that exact figure. But the infill portion of as shown on figure 2 on page 2 of exhibit 1, is the large addition adjacent to the field house is 77,260 square feet. And the small addition on the opposite side is 1,635 square feet. So it's a total addition of around 9,000 square feet.
Okay, that you're adding to the existing fire area post demolition.
Correct.
Correct me if I'm wrong, there's a second story as well to the large addition. There's an additional 62.
And the addition on the other side of the firewall there is.
So it's actually a little more than 10,000 square feet total.
Yeah, 15.
Total building area.
Yep.
Do you have an approximate figure on the area that's being demolished? Non-separated.
Portion of the building non-separated being demolished.
Just an approximate. I know you said you could send that, but if you have just the.
Yeah, it's I think it's about 30,000 square feet. Roughly.
Okay.
And, obviously we're putting some of that space back, but in the football wing, which will be separated by the firewall. So it's a net reduction in overall fire area based on the introduction of the firewall, Simmons wing, and the firewall.
Mr. Malay, do you have questions?
So you stated your intention is to build these additions as a type 1B, which is a minimum. I think that's what the word you use. The minimum would be a type 1B. What's preventing you from looking at a type 1A construction, which will give you more?
Based on the occupancies that we have in this building, if we constructed the building out of type 1B, it would be an unlimited area structure. And so going to a type 1A, it seems kind of beyond what would be required by prescriptive code requirements. And it's not necessary to, based on the 1B providing a pretty substantial increase from a non-rated structure to 2-hour fire resistance rated primary structure and columns, beams, and then 1-hour rated roof. So that seems sufficient based on that being an unlimited area building and table 506.2 in the New York State Building Code, that we would be bringing that building up to a level of life safety that was intended by the prescriptive code requirements.
I just clarify, it looks like one portion, which is looking at figure 5, the area labeled C that's new construction, and you're doing as 2B. Well,
yes, and the red dashed line in figure 5 is a firewall that's completely separating item C from the rest of our building. So that's going to be a 2-hour fire resistance rated code compliant firewall that's structurally independent from the existing building and from building C that's in accordance with 706 of the New York State Building Code.
Okay.
So that's considered a separate building in accordance with section 503 of the New York State Building Code.
okay, and so you're building the 1B section to be a buffer between the existing 2B.
Correct. And then on the other side of that 1B section, we are adding a 2-hour fire resistance rated fire barrier to further separate the infill and a small portion that it's connecting to in the existing from then the remainder of the existing building. That would be kind of the boundary between the red and orange space and some of that yellow space.
And that's probably my hang up on this, is that why, in essence, you're looking to get the variance really for this fire barrier. And what you're suggesting is that, you can correct me if I'm wrong, area B to be existing is a non-sprinkler section of the building. Is that correct?
Actually, if we look at figure 3 in exhibit 1, much of area B is sprinkled. So the blue shaded portion and the portion of the building that's directly abutting our fire barrier that's separating the infill from the rest of the building, it is sprinklered. So you would have sprinkler protection on both sides of the 2-hour fire barrier.
So and that is new sprinkling, or is that existing?
It's existing sprinklering, but the portion that's going to be altered as part of our infill and kind of alteration within the existing between the 2-hour fire barrier and the football wing is going to be modified existing system being compliant with NFPA 13, and it's going to be increased sprinkler density from what's currently light hazard based on occupancy classifications to an ordinary hazard.
Yeah, I'm just struck. There's no data that says 2B is better than light hazard in a light hazard condition. It's a gift, if you want to say. But from a performance standard, light hazard, no, unless you can provide me something from NFPA or independent studies that says, and go into ordinary hazard over light hazard as far as sprinkler density. There's no evidence of any difference in performance. Trust me, I've seen this gifted as Lou. It just, in a light hazard occupancy, knowing what this occupancy is, I don't see any increased risk for hazard. Now, if this was a laboratory building and we were providing, saying, hey, we can do this under, whether it's light or ordinary 1 and you want to go to ordinary 2, okay, I get that. But in this occupancy, I don't see the benefit of it. It's kind of like, give me something, but I don't really see that it's a gift. It could be regifted some other place.
And typically the way that some of those NFPA studies work, they talk about the performance of sprinklers more generally. I don't know that they break it down and say light hazard at 98% and ordinary hazard performs at 99, right? We know that sprinklers.
The whole goal of sprinklers is light hazard is to keep it down under flashover temperature. Fire departments, whether this is ordinary or light hazard, there's still an expectation. The fire department still will have to come in and suppress whatever may be there. Just, you know, if you had areas where you're saying, hey, we're doing lithium ion batteries here, we can do it in a light hazard, but because of lithium ion batteries, risk, you can make it, you can probably sell me, but I haven't seen anything here saying hazard here. So that's kind of where I'm at on the sprinklers. And you can put it in there. I just not personally. And professionally, I just don't know where there's a benefit from it. Going back to this 2-hour fire barrier, that's kind of where I'm good with a firewall. In other and you put firewalls in other parts. I'm just it's kind of this piece that bothered me a little bit is around the field house side of itself. And I know you're talking about the footage, you couldn't do that. I get that. The rest of the building, I'm kind of, like when I looked at this is kind of one of those things that I look at. I look at figure 6, section 1, you're kind of showing where your fire barrier only goes up so high, and then it just goes back to this non-rated wall, assuming it's a 1-story. I see why you just did a fire barrier and did a big firewall there. So I'm just trying to get my head around what you're trying to accomplish here. I'm not saying I'm disapproving what you're proposing. I'm just looking at it.
Yeah.
What would seem like, I'm looking at a building that's already too big for, you know, the field house and the other justice. To me, mitigation would be saying, hey, we've got this area that's non-sprinklered, it's too existing, and we're going to sprinkler. That to me looks like mitigation. That's kind of I'm not talking about the field house itself. I'm talking about that to be existing area. And you haven't talked about it. I'm sure there's a cost factor to that, but for me, that's kind of the gap here that I guess you call it's the section B, parts of, is it section B and parts of
The
A?
majority of A looks like isn't sprinkled.
Yeah, majority of A.
Yeah, it's mostly, as you noted, as shown on figure 3, most of area A is unsprinklered.
Yeah.
The piece of C abutting where our new fire barrier and firewall would be sprinklered, currently is sprinklered and modified for the new layout.
We have no barrier between the unsprinklered and the sprinklered, correct? There's no.
I mean, A and B, is there a barrier portion?
Yeah, I'm just trying to find out why was there delineation in the sprinkler coverage? Is there a already existing fire barrier there to create separate fire areas? Sorry if I use fire areas.
So previous renovations did install fire barriers, and that was a previously approved for the areas of the building.
Yeah.
We would need to investigate exactly between area A and B to see where those fire barriers exist. I think that historically that would make sense if there was a fire barrier there to separate those portions of the building, but we would need to confirm that.
Yeah. What's existing? What is that area that's non-sprinkled? What is it used for?
Those are locker rooms and shower facilities. It's all the one team training area.
That's 2-story.
It's all 1-story.
1-story.
There is a mezzanine room, which is the offshoot feature.
Okay. Yep.
But that's all 1-story over there in area A.
So there's no 2-story unsprinklered, it's just the 1-story is unsprinklered.
The field house is it's its own entity.
And there is a fire barrier between the field house and the building to the north, so that is separated. And now it's done. And maybe it's code simple where it's fire barrier separation versus fire.
And again, each application comes before this board stands on its own.
Yeah.
I can tell you that the muted odd came before us with an addition as part of their mitigation. They provided sprinkling on the perimeter. They couldn't get it over the center. In fact, they had fully sprinkled the entire odd, which is the size of the field house here, except that there were some structural issues up over the center. So they said they came to the board saying, we can't do a full sprinkle. So this is a facility that's an hour away from here, roughly the same size, taller actually, and they sprinkled their building in order to build an addition. We haven't even talked about who manned the field house's sprinkler. No suggestion right this moment. But see where I'm coming from here?
Yeah.
That's, you know, it's like you gave us a little bit, built some fire barriers, but you didn't build firewalls. I appreciate, you know, breaking this up more, but you still have a fairly substantial unsprinklered building. I guess I was just trying to figure out, is there a way we can get a little bit? I'm sure the city would have appreciated if this thing was fully sprinklered, but I'm just trying to understand this non-sprinklered wing, which is the weight room, those and the locker rooms and those things over there. So to me, that would be saying, hey, we're going to sprinkler that. I think that would come a long way for mitigation. I'm not saying that's what, I'm just telling you, speaking for me. And I know this, Mr. Thompson, who will ask to speak in a few minutes, he also spoke to that, saying, you know, it's kind of like you're expecting more. So I guess that's kind of what I am. I'm a fire official. I've been on the board for quite some time, and I look at firefighting and knowing what reduces risk and hazard. It's not just to the occupants, but also to the people who actually respond to this too. So I have that tilt. Gentlemen are professionals, engineer and architect, code enforcement officials. We you know, they look at things differently than I do. So at least when I speak, you know, where I'm coming from. Sure. Biased against you or anything. I'm just looking from the fire standpoint. Okay. Right. Questions?
Yes, section 6, so figure 11, section 6. It appears that there's occupied space at one position that's going to be under the support system for the dome.
Yep.
What's, you know, with that dome support system, I'm sure is, I recall it from my past experience, fracture critical, that if there's a failed connection, it's probably a tension structure. If any of those pieces are compromised, it compromises the integrity of the whole system. So now we have an occupied space underneath some of that. What's your roof fire separation, the horizontal assembly there? And, you know, that I get nervous about tucking occupancies under structures like this, where right now we may approve, but eventually maybe, we need a new air handler, a new air conditioner. We're going to tuck, we got this roof space here. It's kind of out of the weather. It's nice, you know, or an area where you're introducing possibly corrosion because now snow can pile up there. And so it's one thing if I see a building of this type with a breezeway, it's simply a corridor to get you from one building to another, but there's still separation between the two. It allows, from my structural engineering background, to say, okay, whatever we can do to protect that, but can you speak to what that horizontal assembly and what that is?
The horizontal assembly in the 1B below the existing overhang would be a 1 hour fire resistance rated roof. So table 601 in the New York State Building Code allows for, in type 1B construction, the roof to be 1 hour, and then the supports for a roof gets reduced from 2 hour to 1 hour.
I don't think it's predicting that it's tucked underneath this type of structure is one of my concerns for a 1 hour, is that because an event in any of that area could compromise that entire field house very quickly without it having to be that significant, you know, like and I don't know exactly what's in there, but do you have any large equipment or if any roof mounted equipment gets added later, those all become potential risks to that field house structure, where the further a building can be away and protect, because in this case, it's a unique building. And so building against it is a challenge no matter what you do, because it has significant overhangs and structure there. And so one of my challenges with that large addition is that it appears to be right up against it. Whereas if that addition had a 10-foot separation, okay, well now I know I've got at least what would be for other buildings around each other, that if something does happen, there's a separation between the two, or we've mitigated the actual overlap there between the two buildings to be something that really mitigates the risk. Just my thought and consideration as I look at this is that you look at A and B have already introduced quite a bit of interface with the field house, and now we're worsening that by adding more building that is just going to be a fire barrier, but not like a firewall, and the horizontal only being an hour. Yeah, we have 2 hour here, but heat rises, and so now we only have 1 hour on the roof. The idea of the roof vents, well, now that venting is hitting a very sensitive structure. Can you speak to any of that, or have you guys thought through that? What your thoughts are?
So with the 1B construction, we did consider the 1 hour roof as a benefit to that structure up above. We're saying, we looked at that structure, how close we were abutting to it. It's not feasible to remove those braces. Those are there for obvious reasons. So our structural engineers weighed in on it. We don't have that that concern of that failing, but we understand the concern if we need to provide a 2 hour roof in that location or horizontal barrier. There's no equipment in that area. Like you said, it is a breezeway. There's roof drains in that area, but no major equipment.
I have one question, maybe I didn't read this thoroughly enough. Figure 5, your indication, part of the work area is section D. What's going on in D, which is part of the Or is it just a descriptive? This is a work area in section D?
D was just basically depicting the work area of the previous phase, because we added signage on the field house. So under the phase 1A project, there was areas E and D were touched with that scope of work.
Okay, so there was no additional changing of placing or modifying fire in D. No. Oh. Thank you.
And you were talking about the structural infeasibility of a firewall against, mostly the field house in that exoskeletal structure. Was that looking at the firewall directly against the exterior wall of the building, or was it ever looked at where a firewall could be designed and installed at the outermost roof projection, which would pull it away from the existing foundations and structure?
Right, so we did look at multiple scenarios where we could install a single structurally independent firewall, or basically a new firewall abutting the existing. If we pulled it off, that's when we'd be looking at this structurally independent firewall, which is where, tell in our exhibits, is where we landed with that, to avoid that conflict with the existing bracing and their footings. And then in area B, there is the deep existing hydrotherapy room that has deep footings. So just pulling that off of there is much more feasible and constructible than underpinning all of that existing structure and interfacing with that existing cross bracing on the field house.
Because, correct me if I'm wrong, I believe if you're underneath that roof overhang on the field house, that can be, you're technically in a way supposed to classify that space as part of the building area under roof, even if it's exterior. If you were to locate a firewall just outbound of the roof overhang, that could then allow you to do a really small infill. It's feasible structurally with a firewall, a small infill between the field house, that firewall, and then allow you to be a completely separate building for really all your space, the rest of your space. Was that type of concept looked at?
Yeah, basically in line with this.
Because that would greatly reduce, even beyond what you are, the existing fire, that type of concept.
So in that, you would be suggesting that the firewall extend all the way up to the elevation of the field house roof?
It would have to go, code required beyond that point. But if it were outbound of that roof overhang, would that be feasible? A firewall that essentially follows the curvature of the roof. Is that type of concept structurally infeasible?
Well, that concept, I don't think we had fully considered that in particular, but we'd have to look at the, I think structurally that could potentially work. We'd have to look at the layout and just the impact that would have on the first floor.
Yeah, I think he's actually trying to get a separate building with that new addition, with the exception.
Part of it.
Yeah.
Part of the addition is a separate distinct building.
Yeah,
Not
the infill, this infill section between the fire barrier and fire wall, that still is part of the field house structure, even though they put a barrier. And they're not asking to treat it as a separate building, they're asking it to be.
I guess we're asking
I'm
for
just,
knowledge.
I'm not disagreeing.
I'm trying to find another way to reduce the infill as as being really more a separate and distinct building versus part of the field.
We're treating this as an unlimited, you guys are asking us to almost look at this like an unlimited area building when it's not. I think to the city's letter, I think they quoted, we're 10 times beyond the area that's allowed. And so we're kind of at a point where it's a really big building. We're dealing with another applicant whose case has been adjourned because similar issue. Really big building where they've done all these additions and infills, took 3 buildings and made them one. They're multi-story, there's hazardous here, there's all sorts of stuff all over it. And they put in 3-hour firewalls in between some of theirs because of their occupancies. But they're once again coming to us trying to say, well, now we want to treat these as separate buildings. And what do we need to do to treat all these pieces that are connected as separate buildings? And so looking at your plans, it looks like you included a few plan sheets, A1, 102, and A1, 103, some plan drawings. And it appears you have a vertical wall that's multi-story. That comes up outside of that roof structure.
Yes, at the mechanical room, we do have a wall coming up beyond that.
That's exactly the portion of that section I think that we were looking at. Right where there's the 1 story in figure 11, pointed at section number 6. So you're seeing that mechanical wall is going full height, but then it lands on top of the lockers.
So that if that wall were to be created, so that firewall, right now you have it as a fire barrier or fire wall?
Right now it would be a fire barrier and it's on level 1.
But then it stops?
Yes, it's not.
It doesn't
And
continue?
then roof is rated based on construction type, but then the exterior wall on the second level of that portion is not.
But for me, that's kind of where I just, my eyes are like, well, can we upgrade that wall and upgrade that horizontal assembly to protect the field house, should anything ever come.
I think we could make that a rated wall, and we could consider upgrading the roof from 1 hour to 2 hour and kind of having the fire barrier kind of a horizontal jog. And then as long as it could still be a fire barrier, obviously the vertical portion that's above the roof on level 2 there, it's not going to be structurally independent from the type 1B building because it's sitting on the roof. But I think we could easily look at increasing the thickness of the roof, and then, we'll look at the wall construction and get the mechanical room to be a 2 hour on the second floor. So then we're really protecting that portion that you noted, the overhang, the existing overhang. There'd be a full 2 hour fire resistance rated separation that is full height, similarly to the requirements on the firewall. It's just the structural independence would be the main difference.
Yeah, this is built in 62 under the SBCC, and it was of a legacy code which treated things separate fire areas.
Yeah.
The requirements to separate fire areas, that's how you treat it. And even going into the 2003 ICC code, or prior to 2003, the ICC looked at fire barriers as an exception to actually two separate buildings. But then there was a significant code change 20 years ago. They said, okay, we're done with that. Everything is now going to be fire barrier. Even though there's fire barrier there, you still have to treat it under one building in the same areas. And what you're asking us today is saying, we want to, not only do we want to say this is already built legally, but now we want to build new stuff and do infill, but we want to use the same old rules. The code says, no, you can't do the same old rules. You still got to do a firewall because your areas are too big. And that's kind of brings us full circle. I think it was mentioned about a previous case, same situation. Building was built prior to 2000, built under New York State's Green Book, which is its own entity, but it was how do you call it, a maturity of the SBCC, which is the State Building Construction Code. It used a lot of same concepts of what both did and everything else. Fire barriers, fire areas. This total count doesn't affect this total count. The ICC, 20 some odd years now, has said you can't do that. Fire barriers are separate. So that's kind of, and I think that's where we're sitting here struggling. It's like, got an unsprinkler building. Even though this infill is there's not a firewall separating the existing building. To me, that's the problem. And that's where if you told me, says, hey, we're going to fully sprinkler the field house and every other place, and we want to use a fire barrier just to create a separate space, it'd be an easy decision because I can say, okay, that's a minimum. Just haven't gotten it yet. This fire barrier on a building that's already too large for its building construction type, because those old rules don't apply.
Sure. I think just to add a little context, I think that the key points that we would say is that, yes, we do have an existing non-conforming structure and we are adding space to it via the infill. However, we are, via the demolition and construction of a new building that is separated by a code-compliant firewall, reducing the overall area of the existing building to a number that's less than it currently is existing. I think that the board earlier in this call acknowledged that typically it is the intent of the existing building codes to result in a building that's more compliant with the code and that provides a greater level of life safety. I think by adding the firewall, doing the scope on the football wing and pulling that portion out of the existing non-conforming building and increasing the construction type of a portion of the existing as well as the infill, and reducing the fire area by adding the 2 hour fire barrier, because the new code still does allow us to separate fire areas via fire barriers. We are adding multiple layers to this existing building that are increasing the level of life safety, that are decreasing the existing non-conforming nature of the building, and ultimately making the building better than it is today if we didn't complete our scope of work. So I think to your point, we acknowledge what you're saying, what the intent of the codes are. I just think with some context, we are providing mitigating measures, and our scope of work is in line with the intent of the existing building code of New York State, that our building, our state building code, after our scope of work than it would be prior, right? But that would be the argument.
Yeah, it's the info. That's the, I'm not gonna, yes, you're reducing the overall space, but you're still 1,000 times over for this whole area. And so, yes, you pull it back, says, yeah, well, we took this piece off, but we still want to build this new piece. Say, okay, build firewall, make another firewall. Obviously, a little bit of challenge, not so much between E and C, because I think that's doable, but it is a challenge looking at the dome size. I got that, you know, and I think what Mr. Leiter was pointing out, saying, well, what if you built a firewall here, just cantilever it over, so we have structural independence from a disaster, fires. Not sure that would. I don't think it would be gained, but I think structurally, I think it really comes back to the technical aspects of this is a really, really big unsprinklered building. So we're all just trying to find where that leads. You think it's the fire barrier? Me, fire person, I'm looking for sprinklers. So that's kind of where I'm sitting here in this conversation. They're looking structurally. Obviously, they're thinking about, well, what happens if you put a whole bunch of split units, HVAC units, or other mechanical things on the roof over the fitness room underneath the dome. What's the hazard? That's another thing I had thought about this. Well, if you do put structural, maybe you should just put sprinklers above it, over the outside of the dome, since the dome is hanging out over this new structure that you're building. Yeah, just somewhat. This is spitball conversations.
So something else, if I may,
yep.
We alluded that it was the first phase of a 6-phase master plan for the entire facility.
Yep.
So the area C and area E that is unsprinklered currently, yep, is part of a future renovation that is planned to be fully sprinklered at the time. So sprinklering now would just, in 10 years or whenever that renovation happens, would probably get renovated again and re-implemented.
Yeah. Going back to a previous conversation, I can tell you that 20 years ago, I heard a university say, oh, we're going to build this and we're going to sprinkler this building. Today, it's still not sprinkled. So just, it's reality. There's no, how do you want to call it? It's kind of, it's not a stick in the carrot. There's no assurance that any of that's going to happen. You say that 10 years from now, things change, they don't happen. So this is our standpoint when you're doing projects like this. This is where we're trying to find out. Where can we make this building a little bit better? Fire safety, fire safety state, but also occupancy. All right. Let's put you guys, have you take a seat, and we're going to listen to Mr. Thompson talk about his thoughts on this.
Good morning again.
Morning.
Again, it's Brian Thompson, BrianThompson. Address is 201 East Washington Street, Syracuse, New York, 13202. Just a quick correction. At some point, someone had mentioned the address being 1301. The legal address is 1315 East Walnut Street. So I just wanted that maybe noted for the record. Again, I'll kind of be speaking for Deputy Chief Davis, just because he's not available today, but I did speak with him about this. The city doesn't disagree with any of the mitigating factors that the petitioner listed. We would have some concern. Some of the conversation up here was regarding how to or if you could move the fire barrier closer, or the firewall closer to the field house. And the city would be a little bit wary just because of that overhang and how that would react in case of a collapse, because a firewall is supposed to allow for collapse on either side. And I'm not sure of if you move it real close, and you, how that's going to work in terms of a collapse, especially being a that field house type building. Not knowing exactly how it's constructed, but obviously some type of tension members to support that roof. React. The city did suggest in the letter that we wrote the possibility of adding or sprinkling the entire structure, whether that be immediately or over time. We thought it was reasonable that they would do it over a period of time based on the next forthcoming phases of their renovation. But I understand also that might never come to fruition. So the apprehension there. I don't really have much to share that did include in the letter. I know it's a big ask. The code obviously has allowed over time this to be constructed. And now holding it to a new standard, you look back and you're over 10 times what your allowable area is. So that's a tricky one. I don't disagree with that. It's a hardship, but again, it's just making sure that whatever, if anything, is approved, it provides the occupants and any responders of those particular level of safety that the code intends.
Questions for Mr. Thompson? Ms. Goins, do you have any questions for Mr. Thompson?
Not right now.
Mr. Garlock?
You performed a full code review of the project?
Yes, I did make comments. They have not yet responded. I'm assuming they would be waiting to see what happens here for a full response. There were some questions on the continuity of the firewall, but I think that could be resolved by literally shifting the door. It looked like they had kind of bumped the door in at one point in time in the hallway. Nothing seemed unresolvable. The biggest comment I made was the addition exceeding the allowable area. If you have questions on other items that you might have looked at.
All right.
Good. I think we're all set. Gentlemen, you might as well come back up. It's probably have a few more questions. I think the only piece that's to me is understanding the separation between sprinkler, non-sprinkler, or over an A, whether there's a barrier there or not. Drawings are not conclusive to me that there is any barrier. It seems like they just started up with a sprinkler in the area. I guess that's what I was trying to find out was historically why it ended up, other than they did a renovation.
We certainly have that information. Just not
You do?
that we can send. We have the existing conditions and where the existing fire barriers would be prior to our scope. That we have existing the last addition that occurred to the building was.
Yeah, I mean, that separation in A and B in the sprinkler area, I think that would be, from me, very helpful because I'm still trying to understand how we got.
Yeah, and the design team was focused on the fire barrier between B and C, primarily because that's where the scope of work is.
Right.
The extent of the sprinklers extends into A and B, which is not quite where the scope area is, but.
So which phase is the infill? Is that which one is? If you're telling me, because you said 6 phases, so what's the next phase what's the first phase that you would do?
So the first phase was kind of 2 parts. It was phase 1A, which was built earlier this year.
Okay.
And then this is the phase 1 of the construction project. Phase 2 is actually the area B/A of the building.
Okay, so this is phase 1, and then there's phase.
Yes. And phase 2 is in, I believe, area E. And I'd have to confirm. I think 3 is or 4, I believe, is a field house, and 5 is the rest of the original Manly. Then 6, I believe, is Carmelo.
Is that part of I want to say, a board adopted capital program? Like, is that something that could be shared in some form, maybe not exhaustively, because whatever information we have, but that the university would share with the board to show right now, because we're looking at this, and we keep hearing about, oh, we're going to do these other things, and none of that was made part of the case. And so if we see that at some point there's going to be significant remodeling, well, now looking for those opportunities versus, to me, it would be helpful to see some of that. Not exhaustively, would necessarily be something I think that would I'm part of the record, but not a decision-making document on our side. But it would show, as you're talking about these phases, we don't see those phases at all in any of this documentation. So it would be helpful.
Sure. I believe we could talk to the university and get that
a summary of it, brief scope of work.
I think I'm probably ready to go to deliberation. I think there's something I need to say, just that I think there's more information. What's that? Yeah, just a second. I'm going to make a statement, then I want to hear what the board has to say. I think there's more information that I kind of hope, a little more details about these adjacent areas, and not to sit there and make a decision today, but to maybe give you a chance to get us some more information. We can share that with Mr. Giulia. We can communicate that in a letter saying we want you to come back with some other thoughts we have on that. But that's kind of where I'm. Does anybody feel? Well, let me ask Jackie. Do you think you need more information, or do you have enough information to make a decision?
I'd like some more information on the overall picture that was being questioned earlier. I feel like I'm looking at this with tunnel vision right now. So
yeah,
I know we can't predict the future, and the other projects may or may not happen, but before I make a decision, I'd like to understand where they're going with this.
So, again, thinking of the other case, I'm kind of in the same position as Jackie, that just understanding, like, we got where we are because additions were made under the code that they have now, and we can't predict where the code's going to go, but if we can see that there's another addition going to be asked for, in 6 phases, or are you going up, or are you going out? Like, because these facilities tend to, we need more space, and it looks like you guys are trying to build out a great program, and that's great to see that investment happening. And so, by no means is the board at all questioning, like, this is great to see, but we got to make sure it's implemented in a way that keeps that investment safe. And so, to your question, Mr. Parsons, I'm inclined to adjourn, come up with a list of kind of more information. I am curious at the separation between A and B, what that actually installed looks like. And then what are future development, what's a, you know, as far as what's an adopted timeline of what that looks like. And kind of be able to needle that down and have you look at, like when I look at the other buildings, how were those additions considered? You know, were they considered where, like we have floor plans, but we don't know the barriers in between, like is it truly there's separation, just a breezeway type structure connecting them with some infill, but where under the rest of that overhang, what does that building look like and how has the code treated that? So that we don't, you know, the existing building code says we're not to extend any nonconformities. And so I want to make sure that if there's something that's there, that we're not just repeating what was done on that side, that we're really trying to do this right, given the rules that we have now.
And I'm just jump onto that. I'm reluctant to sit there and say, establishing a precedent for this particular building, saying fire barriers are sufficient. It's kind of the message I don't want to send. If you're going to tell me that, oh, we're going to demo A, or build a brand new structure, okay, then we're still dealing with a large field house that's unprotected. Not saying that is ultimately a high hazard, but uses change in buildings. For example, what used to be athletic fields or event spaces are now becoming, not to say the Syracuse University would use it, but for example, things could be used as the RV camper show could be used inside the field house, which increases the risk. Today we see mall buildings that are becoming converted to healthcare facilities and to other uses. While we can't predict the future, what we have to know is what today decision could actually have effect on safety in the future if the use actually changes. So use within the scope of its legally allowed use today. So these are all things that we have to weigh in. So knowing where you're going with your project and where this is going may get me to a place where I'm more comfortable with this barrier concept for this. And speak for me, that's the hang. Firewall, I'm good with what you're doing with that. I understand your challenge on the wall. I'm just wondering maybe a different design might be called for, but I don't want to say that without more understanding of what Mr. Inlighter said. Where's this project going? What's the look forward and how much faith are we putting in? Because what we anchor on this project today, experience, we can't hold you in the future. Even if I'm not sure we could actually put a stipulation saying anything that happens after this, you can't do it again. I think that's beyond the reach of this application. So future is a future, and we assume that any future use beyond this work area, the book's wide open, and you can do whatever. The university can do whatever it wants within the code, and we can't predict or try to influence on it. So and to assume that you're going to be allowed to use the maximum capabilities of this space to what the code allows today. That's what we would assume outside of this work area. So that's kind of the piece we're trying to struggle with.
Sure.
Okay. Sorry, Mr. Garlick, I jumped in front of you.
No, you're okay. I'll just add, I understand, I appreciate, the initial, the reduction in really the building area by separating the new football wing from the rest of the building. However, it's really the infill piece and the square footage of that and adding that post demolition to the building that for me is, that's, I think, the hang up. I think there is possibly looking at the plans, maybe a more sensible solution to further reduce the infill by either relocating the firewall or having at least components of another firewall located in the design to help try to further separate structurally the infill from the rest of the building surrounding. So ultimately, I think it's that area that, I think in any event, reducing that, there's gonna be more than likely, with an addition, the need to add to the existing fire area. Because you can't locate a firewall right up against the field house, right? But reducing that as far as possible seems to make the most sense. So that the actual infill that you're seeking a variance for is much more greatly reduced. So.
And the other part too, in the infill area, if it was a covered walkway, different use, so we would be comfortable saying, oh, it's just a walkway. This has actually got activity use spaces in there, so there's higher level of potential hazards, although they're light, they're still. Okay, all right, I think I know you don't have to do deliberation. I think what we can do is, we're going to adjourn your case. Maybe, how much time do you think you would, well, you probably see it zero less, but maybe September. Try to bring this back.
This is our next hearing.
It's pretty enough.
And it's right now. So September.
Hey, Tom,
Yes.
we need to vote on that if we're gonna adjourn.
Yeah, we need to make a motion.
Yeah, we're just trying to make sure we understand that we're gonna be. You have
Turning around in August if that is possible.
Yeah,
We could gather the documentation and get that ready for you.
if you could have it back to us August so we can discuss it. It's a timing thing. We don't know ever. You pressed on a time schedule that you gotta get a decision from us like yesterday or.
Project is.
Yeah, these cases are a little more complex, and so the more time we have to read it, look at it, will save time and kind of having to review it on the fly. So.
We need to do in August and get that other case. Let's split that out.
That's fine, because I'm not speaking.
You're not speaking? What? So if we need to split the cases because of that other case, I can't hear.
Yeah, I'll bring others in. So everything.
Okay, if you get the stuff to us in August, and if we have, there's another case that I'm recused from that, so typically I don't come to those meetings. But because of this, we may split the hearing, so two cases.
So, may I ask a question?
Sure.
If we were to commit to sprinklering the rest of the area between A and B, would that ease any concerns? In addition to upping the 2-hour fire variance we talked about, mechanical agreement at the roof by the field house.
I'd say probably that would go a long ways, but I don't want you to end up sprinkling something you're gonna end up demoing in 5 years. I get that. That's why it's kind of one of those cart and horse, chicken or the egg, whatever you want to call it. I don't want to put the university in a situation where you're gonna, that you know that you have to come under schedule yet. So I guess that's, and maybe that's something you want to talk about outside of this. Because I mean, I truly don't want you to go do it. If you want to say we're going to commit to do this by such a date, we might be able, that might be sufficient pushback. Then you'd have a choice. You got to do it, or you got to do your other project. Maybe that actually works in your favor for getting projects. So you can think about that. And maybe come back August and say, hey, we do this. Let me just, and you're going to see this in this email. You know, we're focusing on this area underneath the overhang. That's an area that these two gentlemen, and I'm not saying I'm not concerned about it. They clearly are concerned about this separation. So you might want to think about how to address those concerns about this building underneath. Trying, what is it? So that's truly a new piece that's being plugged into the side of it. So, all right. So I guess with that, I'm going to make a motion that we adjourn this hearing until our August meeting, and if necessary, September, to the applicants. And we will, and part of my motion is we will prepare more precise questions for you to address. Okay.
I'll second your motion.
Thank you. Ms. Coons?
Aye.
Mr. Garlock?
Aye.
Mr. Delaire?
Aye.
Chair votes aye, 4 ayes. No nays. This case is adjourned until August.
Thank you.
Thank you, Rob.
That's our last case. We can go off the record. I want to thank Maureen and staff for your support today. Thank you. Jackie, yes, thank you, Jackie.
Thank you. Before we go off the record, could I get Tom's last name and spelling, and same with Josh, please?
My last name is Apollonius. That's Apolleni.
First name is John.
Joshua. K-O-S-H-U-A.
Josh, I'm sorry, what did you? Did you say your last name is Apolleni?
S.
Okay. Thank you.
Apollonius. Yes, thank you.
And Tom Weirs, W-E-R-R-E-S.
Thank you, Tom.
Okay. And
Thank you, everybody.
Thank you, Barb. Thank you, Jackie.
Thank you.
Have a good day, everybody.
You too.